So we're going to discuss estate planning today from a financial planning and a tax perspective. So I shall kick off on the financial planning side of things, and then David will take over from the tax perspective. So I suppose what I wanted to cover today is scenarios where gifting may not be possible. What else can be done? So obviously, tried and trusted methods of gifting into trust or direct gifting and gifting from excess income, widely used methods of estate planning. However, there are often practical considerations which prevent outright gifts or trust planning being done. Common fear of clients of will they have enough for themselves in the longer term, not knowing how long they're going to live or what their later life care needs may be. What can they do about IHT exposure without giving up control of the asset? Well, I'm going to talk a bit today about some investment-based solutions that can have powerful IHT mitigation results where the client can retain 100% ownership of the asset. So something known as business relief, used to be called business property relief, where clients can hold a specific type of investments and after a 2-year qualifying period, if they're held at death, the inheritance tax rate on those would be 0% rather than the punitive 40% level that we're all used to. This relief is granted to trading businesses in certain sectors, and from an investment point of view, these can be unlisted companies or indeed AIM listed companies. So AIM is the junior stock market in London. They can pay income if needed, but crucially, the client retains full ownership and control. So there's not a lot of things you can do that lower the IHT bill without giving up some ownership or some control. This is one of the few. Now, how's this treated on first death? You might question. Is there a second qualification period needed for the spouse after first death? The answer is no. The business relief is maintained on first death. So this can be really powerful sort of first steps into estate planning for those clients that aren't really wealthy, where there can be 100% sure of outright gifting. So on the listed variants of this type of investment, they're usually daily tradable. The unlisted variants, currently the average for accessing the funds is around a month. But as you can see, they're quite short periods to realise capital if circumstances change in regard to health or need for capital. Unlisted variants of business relief investments can usually target particular sectors, and these can be attractive for lower risk investors. They tend to have lower volatility and low correlation to traditional stock markets. So we saw a particularly acute test of this in March 2020, where the coronavirus spreading caused quite a sharp sell-off in global equities. Some of these strategies, barely wobbled from their line because they're invested in different things. So that can be an attractive part of a wider investment piece for a client. The listed variants can support ISAs, so that helps from a tax planning point of view. You may be thinking, some of my clients are business owners. If they're trading businesses in those qualifying sectors, then obviously their shares in those potentially family businesses should qualify for the same relief until, of course, they may exit that business. A lot of people who have a lot of their value in their business don't have an IHT problem until they retire, they exit the business or sell the business. Then a lot of value can come back into their estate, and then suddenly they've got a problem. Business relief investing from a retail investor point of view can help to control that problem. Now, obviously, the 2-year planning helps compared to the 7-year planning. 7 years is quite a long time to be certain that health is going to be maintained. A financial planner can help if 7-year planning is being undertaken. You can arrange some insurance for the intervening period to cover that, to cover the exposure in the short term until that gift succeeds. Those policies are known as gift inter vivos. So we've got some of our Latin still in use today. So next I want to come on to ISAs. So ISAs are obviously a wonderful tool to accumulate tax efficient wealth during our lifetimes. Great for tax-free growth and withdrawals. What we find is a lot of clients are very good savers, and actually some of them overestimate how expensive their retirement lifestyle may be, and they end up with quite significant ISA savings pots that they don't really need. And as they get on to sort of mid to later retirement, it becomes clear that these things are going to present a problem for inheritance tax, because whilst they're wonderfully tax efficient in lifetime, they're usually just fully accessible for IHT on death. So the listed business relief qualifying investment companies that I mentioned a minute ago on the AIM market, so about a third of the AIM market will qualify for business relief, and you can access specialist AIM ISAs, which allow you to persist and maintain the tax benefit you've built up, tax-free growth, tax-free dividends, if you need them, with the added benefit that after 2 years, that the IHT rate would be 0% rather than 40% on death. So depending on the risk profile of the client, the unlisted solution or the listed solution, or a blend of the two, can work very well to attack the IHT problem without necessarily giving up control or ownership of the underlying assets. The next one I want to talk about is debt. Now, this one is not overly popular, but so from a technical perspective, it works better than a real life perspective. But some clients who are more pragmatic and scientific about it would embrace it. Now, obviously, if you've got debts against the estate, then your net estate will be lower. So some investment managers have the qualification with the regulator to take deposits. The permissions are correct, and that allows them to offer overdrafts and loans, basically. And they use if you've got a certain amount of investment, they use that as collateral for the loan. So this can help short-term capital requirements. It can help with tax planning, and obviously if it's used regularly, if you've got something outstanding upon your death, it could help reduce the estate. the main one, of course, is principal private residences of high value. So the idea of leaving the house to the children is a common one we hear, but actually when you look at the estate as a whole, if there's significant assets in pensions or business relief assets, etc., then whilst the client is keen to stay in a high value home, there's only a few things you can do about the inheritance tax due on that if it's over the allowances. So one thing you could do, of course, would be to borrow against that property, release some capital from it, and either use that to improve the lifestyle in retirement, or indeed to fund gifts or fund other types of investment that might be more efficient. Moving on, so I couldn't talk about estate planning without doing a quick slide on pensions. Now, I'm sure many of you have heard me talk before at length about pensions, but a quick reminder: post pensions freedoms 2015, many people consider the modern pension to be the number one estate planning tool that we have available to us. The vast majority of cases that the pension will be entirely outside the estate. So what can we do? We can consider the order in which assets are drawn down in retirement. So not necessarily think to go straight into the pension once they finish work. Coming back to the previous slide about ISAs, if you've got a large ISA inside the estate and a large pension, why draw down on the pension immediately upon ceasing work? Why not draw down the ISA first, which is sitting inside the estate? So yes, in the later working life, to look to maximise contributions whilst pensionable earnings or profits continue to be generated. Consider if you've got a business exit coming, to filling up the pension before you go, to avoid that shock of the value of your shares all coming back into your estate. It's attractive because it can not only go to your spouse, it can go on to your children, it can go down to their children, as long as the value maintains. There is no effective limit to the number of generations it can go down. So consider that as a waterfall or a cascade of wealth down the generations, which can be very helpful. And just to finally remember the wide investment universe that's available in pensions: commercial property, agricultural property or land, huge range of stocks and bonds globally, or up to 5% of even the owner's own company shares. You can also leverage using lending to buy bigger property assets, and you can come in with business partners to buy premises, with other family members to buy property. So finally from me, just a small reminder on the small gifts allowance. So at the lower end, a couple may be able to afford to use the £3,000 per annum small gift allowance to their children or grandchildren. Now, we know the attraction that this is, because it's within the allowance, it's immediately outside the estate. So you might argue there's a 40% saving immediately. Now, if that's just put in a bank account, then that's the end of the efficiency there, and the money has to deal with inflation. So in the current climate, you wouldn't have to wait long for that 3,000 or 6,000 to be devalued. And if it was grandchildren you were saving towards education or something, it could well shrink in real terms quite noticeably over those years. Looking at the scenario where you give it to adult children, if your working age son or daughter, for example, has a pension, then and the gift is paid into the pension, that gift would attract tax relief at the son or daughter's marginal rate, so 20, 40 or 45%, as long as they've got as long as they're working, they've got the tax liability to do that. So you can upscale the gift from there. So in the situation of a higher rate payer, for example, you could harness up to 6,400 of tax benefit on top of the £6,000 gift. This is a combination of the inheritance tax saved and the income tax relief on the pension contribution. So, effective tax relief somewhere around 107% now. And I know David would be a particular fan of such numbers. So just considering really what's the best use of the gift if it's not needed, to be spent cash immediately, on school fees or whatever, then if you can look medium term, that could be very helpful and a great outcome for the wider family. If they need it earlier, obviously it could be paid. They could use it to fund an ISA subscription, for example. Thank you for listening to me today. I'm going to hand over to David Krause, who's going to cover more of this subject from the tax perspective. David, over to you.
Thanks, Tom. Good afternoon, everybody. I'm going to focus on lifetime gifting. I know Tom's talked a little bit about some of those things already. Yes, it's an important part of the estate planning advice that we're giving to our clients. So we're going to talk about why people are doing it fundamentally, but in particular, I want to talk about some of the alternatives that we're talking to our clients about on, you might say, the tax advisory side on you might say, alternatives to lifetime gifting. I'm going to flip on to the next slide, Tom, if we've got our concepts. I'll be touching on lifetime gifting and alternatives, and I think we just got a reminder at the end on trust registration. So for those of you involved in advising trusts or trustees, just an important reminder about some action required in September. So lifetime gifting, why do people want to do it? Well, I suppose it can bring great joy into the lives of those that you're gifting it to, whether it's friends, family, starting off on their journey of buying a home or starting a business or their own investment journey or following their dreams, or for charitable causes. Some valuable contributions that you can make in wider society by making those sorts of gifts. I don't think I'm telling tales out of school to say that a lot of clients that we'll talk to will have the 40% rate of inheritance tax in their minds, and that will be influencing their feelings about looking at lifetime gifts. Of course, it's not as simple as looking to give it away to avoid the 40% IHT cost, because they've got to balance that with, as Tom was saying earlier on, affordability, people living longer, the price of care in the future. But of course, a lot of clients are concerned around control, and certainly the biggest thing that clients will talk to me about is, sometimes they won't be talking to their family about it, but they'll be talking about concerns over marriage breakdown. And of course, if we are passing assets down to the next generation and there's some sort of divorce, say, then 100% of those assets might disappear rather than 40%. So a lot of desire to do lifetime gifting, but a lot of things to consider when doing so. An important reminder, of course, if we're giving assets away during your lifetime, that we've got capital gains tax to pay at market value. So even though we're not receiving anything for the gift, capital gains tax is payable at market value. And those of you who are get interested in or work in the field of residential property will know that today we have to report and pay the capital gains tax within 60 days of disposing of a residential property if capital gains tax is payable. So a lot of reasons to want to make lifetime gifts, but a lot of concerns, a lot of things that need to be addressed in that regard. Tom, we go on to alternatives. So in trying to address all of those concerns or just some of them, this is it's bold to call it a checklist, but certainly this is a list of all the things that are in our toolkit, if you like, in terms of advising our clients on what to do. So I just want to talk about a few of those in a bit more detail. The first one probably doesn't seem too scientific, but sale under value. A lot of clients will think about gifting as quite binary. I give it away or I keep it. In fact, you can do something in between, because you can give away in some cases a part of something, or you can sell something under its value. Now, from a capital gains tax point of view, as we just said, the capital gains tax is still based on the market value, but by selling, actually we are creating some sort of inflow back into your estate if you need that for affordability reasons. We'll have a client, I've already mentioned this example on numerous occasions, but a client who sells a buy-to-let property worth several $100,000 to their son for 40,000, which also happens to be the threshold below which there's no SDLT, and the son is repaying hundreds of pounds every month until such time as that runs out, which hopefully will coincide with the receipt of mum and dad's state pension. So again, you can try and calibrate. It's not a binary outcome of gifting or not in that case. Tom's already talked about pension savings, and certainly we'll just echo those same sentiments. I think we'll see a lot of clients now who are putting money into pensions, not because they're deeply concerned around providing an income in retirement, although of course that's what can provide, but actually it's an IHT sheltering device. And we'll have clients earlier this month up till yesterday, end of the tax year, taking cash savings, loaning it, for example, to their investment companies, and the companies making pension contributions. So as well as putting it outside our estate for IHT purposes, we're also getting a tax deduction for that in our corporate. So yeah, pension savings are a huge part of IHT planning, and an alternative to gift, because the gift coming at some point when you're deceased, that your beneficiaries will then be able to, in a lot of cases, access that pension savings free of inheritance tax. Tom talked about business assets. And of course, there's a marketplace for those sorts of things, and Tom can advise brilliantly and accordingly. For a lot of clients, they already have trading businesses in their lives. So they might own a trading business, and they might be part of a family that owns a trading business. And often there's a lot of conversations with our clients around how we can make best use of business relief. So we will have cases where, for example, there are some investment activities and there are some trading activities, and actually you can get a better IHT outcome sometimes by separating what you're doing or by combining them in that regard. So can we, for clients who have that sort of profile, are we making best use of business relief as an alternative potentially to making a gift? Lifetime trust is something that I guess a lot of you will be deeply familiar with. I think I'll mention that again when we come to partnerships in just a minute, but I think we're all familiar with those concepts. Share rights variations. Obviously, this is relevant where shares are the subject matter. So we're talking here about companies. And so we see plenty of clients who've got investment companies reconstituting their articles and having different classes of share in order that you might say the increase in value of the underlying assets in the company accrue to one class of shareholder and not the other. And of course, our clients may well be those that have those earlier, that have the former class of shares, not the what we call, perhaps we call them the growth shares in that regard. So again, an alternative to gift, but which can deliver some reduction in the estate for IHT purposes. Partnerships, certainly for wealthier clients, certainly clients with large amounts of investment assets, for whom gifting or control can sometimes be issues. That we are, there might be a family partnership angle to that, for example, by placing those investment assets into a partnership and have other family members as partners. So we have a number of clients using limited liabilities partnerships for that purpose, and our client is the designated member, so they're in control. Generally speaking, they're managing these investments, but they'll have other family members as ordinary members or members in that LLP, and in some cases we've got like family trusts also participating as members in there, and really the purpose of all of that is to allow our clients who continue to have income to some extent to continue to have some element of control, but to be able to try to manage their estate. So that actually what we find is that their estate is reducing over time rather than getting bigger, as it might be in the case of perhaps taking no action. I think in some cases, in some slightly sadder cases, I suppose we've got cases where we have spouses that are very different in age and perhaps very different in their in their health, and so if we have a client who is sicker or that actually in some cases we're transferring those assets to the ill spouse, that their will then transfer those assets to the surviving spouse, perhaps the younger spouse or healthier spouse. What that will happen at that stage is that transfer on therefore will be exempt from inheritance tax, assuming we've got 2 UK domiciled spouses. But then that would allow the spouse number 2 to be able to gift those assets away, because the gains on those assets, if there are any, are washed out effectively at death at that point. So we'll have a smaller number of clients who are applying that strategy, which is slightly macabre, but actually is appropriate in those circumstances. I think it's also just worth talking about what we're doing with clients and their main homes. So all of these ideas around partnerships and trusts and pensions and companies, in some instances, I think can often suit all assets essentially other than the main home, because there's a huge amount of tax rules, not just inheritance tax rules, a huge amount of rules around what you do with your main home, whether it's in partnerships, in companies, and all sorts of detailed and complex legislation. So the main home I sort of consider as a separate exercise in terms of planning for their other assets. But in terms of what clients are able to do with their main home, a lot of the innovative schemes have been closed down, but what is still possible is a sale and a lease back. So clients, for example, might give away a share of their home to, let's say, the children, and pay a market rate rent for that continued occupation. And for the right family, the right circumstances, that actually you can see that the rent and then the income tax that's payable on that rent for the rest of their lives versus the potential IHT saving is quite significant in that regard. So I say we don't have hundreds and hundreds of clients lining up to do that. I think the main home is clearly a huge emotional step to take action in that regard. But okay, we will see some work in that area, and occasionally we will see benefiting clients who can benefit, families who can benefit from inheritance tax relief in relation to joint ownership. So if you give your home away, or you give part of your home, say, to a child, to say a son or daughter, and they then live with you, that isn't caught generally with a gift with reservation rules that would apply if you gave it away and they didn't occupy it with you as well. So when it comes to the main home, a couple of aspects there that we continue to see. It's right to say that almost all of those things, maybe pension savings aside, involve quite a decent amount of legal work in relation to all that, and actually that just needs to be structured absolutely correctly and clearly so that the clients are getting the outcomes they want from the legal perspective, but also making sure that we are satisfying the tax rules in each of those scenarios. So a lot of legal work, I think, will go alongside all of those particular alternatives. And then just finally, just a sort of a highlight of those, for those of you involved in trusts or advising trustees, for non-tax paying trusts, there's going to be a requirement to register from 1st of September and to complete an annual declaration via the Trust Registration Service. I would tell you a lot more about it, but actually I don't know a lot more than that, and Brad and Dean are the gurus on that. So if you want to visit the Trust Registration Service page on our website, that will tell you a lot more. There's a fact sheet on there with more of a comprehensive explanation, but Brad and Dean would be, I think, entirely content for anyone here to reach out to them if they want to pick their brains on what's required by the 1st of September. I think that might be it from me, Tom. Yeah.
Lovely, thank you, David. And I think looking at the time, we've reached our allotted period. So I think we'll thank you for the questions. We'll take those offline and come back to you individually. We're always happy to hear from our friends and contacts in the legal community if we can assist on any cases, help you deliver a better outcome, then please do get in touch. As I say, a recording of the webinar will be out next week, I think, to share around colleagues or those that weren't able to attend. But for now, enjoy the rest of your afternoon, and best wishes from both of us.